Good morning. We're back in Senate Judiciary on April 8th, and we're taking up page 772. We're going to be sticking to the judiciary related aspects of this bill, of which there are many. There are some economic development aspects of the bill that we're going to stay away from, but we have led counsel here to provide a walkthrough. So the floor is always awesome.
Good morning, Cameron Wood, Office of Legislative Counsel. I'm here to talk about page 772. I believe you'll have a copy, so I'll have to share my screen, but I can, so if you would find that to be helpful. How would I would articulate this bill, right? It makes a lot of changes to the residential rental agreement chapter that exists in Title IX, which governs the relationship between a landlord and a tenant. It governs everything from security deposits, application fees, obligations of the landlord and the tenant in the landlord-tenant relationship, etc. The next part of the bill deals with the ejectment process, the process of a landlord going into court to receive a writ of possession to ultimately remove an individual from a dwelling unit if the court orders that the landlord is entitled to possess them. And then there's the last section of the bill dealing with the residential rental pilot program, and I won't get into that. But I will have to start a little bit with the residential rental agreement, the landlord-tenant relationship, before I can jump into the ejectment language directly. Because in order to get to an ejectment, first off, there is an agreement that's in place, and the agreement has to be terminated. And the statute outlines what notice periods have to be required by the landlord. How much notice does a landlord have to give an individual tenant in order to terminate the rental agreement? And the notice period is going to vary depending on the reason that the landlord is terminating the agreement. So if the landlord is terminating the agreement, for example, because the tenant is not paying rent, that is going to come with a specific notice period. Separate if the landlord is terminating for what you might hear is just say no cause reason. Your lease agreement expires at this period, and I want to terminate the agreement with you and no longer want you to rent from this dwelling. I need to provide you with a certain notice period, and that's going to be different depending on what the termination is for. I'm bringing this up because you have to have a termination of the rental agreement and the notice for that termination, that notice period, before you even get to the ejectment process. If a tenant remains in the dwelling unit after the termination period, after the notice period provided, and they remain after the termination date provided in the notice, then the landlord has to bring the ejectment action to receive from the court an order, writ of possession, that the landlord has a legal right to lawful possession of that place. And then ultimately that writ would be served on the tenant by a sheriff. And then the sheriff ultimately would come back and then have to physically remove the individual if the individual remains after a certain period of time. So I'm just trying to kind of lay the foundation here about what happens to get to an ejectment action. First, you have the relationship, then you have the termination. The person stays after the termination. Now what? You move into the ejectment process. I won't really walk through the language of termination and the notice periods unless you all would find that helpful, but I will say that the bill is making changes to each of those notice periods for the termination of the rental agreement.
I think which section specifically are you referring to?
That is going to be the notice periods themselves are going to start on page 7. It's 9 BSA 4467. In line 14 there, you can see termination of the tenancy notice. Everything in this section is about how much notice is required to be provided.
Okay, I would like to get a walkthrough on that section that it's,
What I can do then, if
but we can also start from the beginning, whichever is
if
the best for you.
what I'm gonna do is I'm gonna share my screen and I'm gonna pull up something that I provided to the Senate Economic Development Committee. As kind of a cheat sheet, if you will. Henry, you mind sending me the Zoom link? Yeah, will please. All right, well, I'm gonna pull this up. First thing I'm gonna start with then, if we're gonna talk about notice period, the first thing I want to talk about is the language on the very first page. Because this is a definition of what's called actual notice. And the language in Title IX, the residential rental agreement chapter, it requires that the landlord provide the tenant with actual notice of the termination. And what does that mean? It means receipt of written notice. So those are they're on lines 11. That's the two key pieces. First off, it has to be in writing and the individual has to actually receive it. Currently, the way that a landlord can do that is by hand delivering the notice or by mailing the notice. This amendment, as you can see, is adding in that it can be delivered by sheriff's service. It can be mailed to the last known address or the address provided in the residential rental agreement, which could be different than the physical location of the dwelling unit. Individual may want to use a PO box, for example. Line 16 and 17, it can be emailed. Or if the last address is unknown, posted to the door of the dwelling unit. And then the next change here on B is
For you,
yes.
keep going, can you distinguish for the committee the difference between actual notice and constructive notice?
What I would say here is the actual notice requires that the landlord has to make sure that the individual actually has it, as I mentioned, receipt. So you can't just say to someone in passing, you know, your termination is, or your rental agreement is terminated at the end of the month and you need to get out. And I argue that by telling them that, they, you know, constructively put them on notice that the agreement is terminating. You have to ensure that the individual actually receives it. So that's a defense. If you end up going to an ejectment process, the tenant can argue that the tenant did not receive actual notice. They may be on constructive notice all day long because you've had some sort of contentious relationship and the landlord has told the person, you know, when the rental agreement is up, you're out. But if the landlord doesn't provide them with the actual notice, which again requires it to be in writing and requires that the landlord demonstrate that the person actually received it, then the landlord would be able to move forward.
And for paragraph 5, I think if the last address is unknown, put to the dwelling unit, is the assumption that the person isn't in the dwelling unit anymore?
I think the intention of that was there are circumstances where the tenant may be intentionally trying to not receive the actual notice. They're not answering the door, or you know they may not be there, but they still have their things there. So my understanding is it's trying to address a circumstance where the individual is intentionally trying to not receive the service and you don't have an address where you can send the stuff to because the person has abandoned the property. That's what.
Thank you.
I will kind of mention, Mr. Chair, you mentioned kind of the constructive notice piece. There is a rebuttable presumption in B because, as I mentioned, you have to ensure that the person actually receives the notice. And how do you do that if you actually mail it? So you have to ensure they receive it, but we're also allowing you to mail it. And so there is a rebuttable presumption that's already built into the statute that says that if the landlord is sending the notice by either first class or certified mail, this is on page 2, line 4. So if you're mailing it first class or certified, there's a rebuttable presumption that the notice was received 3 days after it was mailed. This amendment extends that to 5 days. There was some concern about the mail service from the House General Committee, so they're extending it to 5. And then they're also adding in the rebuttable presumption if it's emailed. Similar issue, how do you prove that someone received something via email? So they're creating this rebuttable presumption. And then also including the date the notice was posted to the door. Okay, so that's the first, like I said, the first change if we're going to talk about the termination period, because again, the individual has to receive actual notice of the termination itself. Okay, now I'm going to pull up a Zoom because I'm going to use this little kind of cheat sheet that I created to talk about the differences in the termination notice periods themselves that's in the bill. Right. Zoomed in enough. Okay, thanks. So what you have here is, this is all about section 4467 that I was just talking about. This is the section that governs how much notice period has to be provided when you're terminating a rental agreement. As you can see on the far left, I've just tried to highlight the different subsections to identify what the termination is for. Second column here, current statute. Third column, the change that's in 772 now. So if the landlord is terminating the rental agreement for non-payment of rent, this bill proposes to reduce that notice period from 14 to 10 days. Then you get into B1 and B2, and B is titled, the kind of assistance heading in that subsection is breach of the rental agreement. B1 currently says, and if you want to get to the language of the actual page, it's going to start on page 8. So B1 is currently the B1 sub I. If the tenant is failing to comply with the material term of the rental agreement or with the obligations imposed under the chapter, then the landlord can move forward with the termination based on that. And the current statute is 30 days notice. What this bill will do is it's adding in the sub 2 and 3. So it's adding in that a landlord can terminate a rental agreement for late payment of rent, which is defined in the section as 3 times within a 12-month period. So it has to be late 3 times in a 12-month period. And the late is more than 10 days after the rent is due. In that event, same thing, it would be 21 days under this bill if it were to move forward as it's currently written. And then the sub 3 is failure to allow access. There's a section that requires the tenant to allow the landlord access to a unit given certain notice periods and under certain circumstances. And if they fail to do that, the landlord could move forward in that event.
And is the 10 days, is that new, or is that, I'm looking at page 7, line 17. Is that what you're referencing, the 10 days?
That's the reduction from 14 to 10.
And that is for
Non-payment of rent.
non-payment of rent.
Yes.
Thank you.
Okay, then you get to B2. There is some change in B2. This is, currently it says that the landlord can terminate, this is on page 8, line 16. Termination if it's based on criminal activity, illegal drug activity, or acts of violence, any of which threatens the health or safety of other residents. The proposal change here is to remove criminal activity and illegal drug activity, keep acts of violence, and add in damage to the dwelling unit or other activity. So you are somewhat, if this bill were to pass as currently written, you're somewhat expanding the scope of activity that the tenant is doing, that the landlord can terminate the rental agreement under this section, because you're removing that it has to be criminal or has to be illegal drug activity, and you're just saying other activity. Other activity is not defined, but it is still conditioned on the fact that it has to threaten the health and safety of other people. So under this B2 here, it would be activity that's threatening the health or safety of other people. The landlord can terminate under that circumstance. And currently it's 14 days and this reduces it to 5 days.
So theoretically, if somebody smokes cigarettes outside, another tenant is complaining about it, saying it's affecting their health, that tenant smokes cigarettes could be swept up in this. If the
I
landlord,
think a landlord could try to make that argument. I would say in that circumstance, the landlord would probably be better if the agreement itself says you can't smoke on the property, of terminating the agreement under B1 of saying that the tenant is failing to comply with material terms of the rental agreement by smoking. If the rental agreement says you can't smoke, and proceed that way, I just think you're probably gonna have an easier argument. But yes, sir, I think that could be an argument that's good. Thank you. Okay. So the reason I highlighted these first 3 blue are because these are kind of what you'll hear from others, outside parties, et cetera, as the just cause reasons for terminating. It's a cause that, you know, the tenant has engaged in something or done something that is giving the landlord cause to terminate the agreement. The rest of these would kind of more fall under the no cause reason. These are the landlord just choosing not to have that individual as a tenant in the unit and providing the required notice. So some of these don't really fit in either category. For example, termination because there's a government notice to vacate the property that's being added in. I don't know that really falls under a just cause or a no cause, but it's there. The key things I think I would focus on right here are the sub E, which is broken up into 2 lines. Currently, if the landlord is moving forward and terminating the rental agreement simply because the landlord doesn't want the person there anymore, you have to ask 2 questions. Is there a written agreement or no? And how long has the individual lived there? Because currently, if there is a written agreement here on this line, if the person's been there for 2 years or less, the landlord has to give them 60 days before the end of the written term. If the person's been there for greater than 2 years, it's 90 days. And actually, no. I apologize, this is the wrong version. That's no agreement. That is written agreement. Excuse me. If they don't have a written agreement, it's 60 or 90 days. If they do have a written agreement, it's 30 or 60 days. I pulled over the wrong version, excuse me. So as you can see, it's really going to be dependent on a few different circumstances, and it could be all the way up to 90 days. What this bill proposes to do is consolidate all of those and make it 90 days. So as you can see there on the column, if you have a written agreement, you have to provide 90 days notice before the expiration of the written agreement. If you do not have a written agreement, then you have to give the person 90 days.
So when do we know there's no written agreement? How do we identify the end or expiration of the term?
You don't, that should be on the bottom. I had this as a previous version, and that should simply be there. So if there's no agreement, it's just 90 days from the day you give the notice. And if it is a written agreement, then it has to be the notice period before the end of the expiration of the term. Okay. So that's where I just wanted to pull up, if you wanted to walk through these things to know what the changes are. As you can see, for the, kind of quote, just cause reasons, they're being reduced. For the, kind of no cause reasons, they're all being extended out to 90 days. So that is the changes to the termination section, which is then going to bring me to page 17 of the bill. And now we're going to talk about the ejectment process. Because again, as I mentioned in the very beginning, you terminate the rental agreement, terminate, provide the notice period, and then if the individual remains after that, the landlord has to bring the ejectment action. Currently, there is an ejectment process already in Title 12. Title 12 Court Procedure, Chapter 169 is related to ejectments. This is the eviction process, if you will. The Senate Economic Development Committee was asking that question: why is it ejectment? Why are we talking about evictions? Is that what we're talking about? Yes, statutory language uses ejectment. And so you currently have in Title 12, there is subchapter 3, Superior Court ejectment, where a landlord goes in and can ask the court for a writ of possession to get legal possession of the property and have the individual removed. A few tweaks to that subchapter. If on page 17, starting with section 2, this is a new section that states that when an individual files for alternate service of process under the current rules of civil procedure, the court has to rule on that motion promptly. So this is where, as you all know, you bring a court case, you have to have the complaint and then, other motions filed, et cetera, et cetera. You have to have all that served on the other party. And if you can't effectuate service on the other party, you can file and ask the court to do an alternate service of process, which could be leaving it at the physical address, a tack order, putting it on the door. So what this section would do is it just requires the court to rule on that motion to do alternate service process. It had language in here that required the court to rule on that motion within 3 days, I believe it was. Judge One came in and discussed starting to stray into separation of powers and core judicial functions about requiring the rule within a specific time frame. And so the House Judiciary Committee ultimately settled on this language of just rule on it promptly.
I mean, it's in fact, this will be a question for Judge Zone, but I mean, isn't it the expectation that courts shall rule promptly on everything that come before them?
I think that you would hope that they would, yes, sir. So section 3, moving into the current ejectment chapter, section 4853A is about payment of rent into court. So when you look at the current statutory framework for ejectments, I'm going to pull it up so we can talk about it briefly. Here's the current subchapter. So it has, the process of, filing it in court, service of process to the other party, and then you see in 4854 judgment for the plaintiff, and then property remaining. And I'll talk about that in a second because there's an amendment to that section. There are 2 expedited processes. There's payment of rent into court, and then an unlawful occupant. So in those 2 circumstances, the landlord can request, if the tenant is not paying rent, the landlord can request that the rent be required to be paid into court or a rent escrow process. And then if the tenant is refusing, or I should say refusing, isn't making those payments into court, the plaintiff can get an expedited judgment essentially. Separate from that, if there is an unlawful occupant in the dwelling, the individual can't sublease the property and it's being subleased, or the individual who was the tenant on the lease has vacated the property and someone who was living with them stays. So
We're talking about current law, right?
yes, sir, this is current law.
And Senator Biddle?
I was gonna ask what an unlawful occupant was. My assumption is that someone that is not legally on the lease that is living
Yes, ma'am.
there.
And so that has an expedited process. And I'm just bringing this up because I'm gonna circle back to this when we get to the new language here in the section. Okay, back to page 17 here. As I mentioned, section 2, rule on motion promptly. Section 3, payment of rent into court. Currently, there's 2 subsection A's in that section. And so I'm removing one of them. This is on bottom of page 17, top of page 18. It allows for the landlord to file a motion that the tenant pay rent into court during the ejectment process. This is a technical change. As I said, there's 2 statutory section A's, subsection A's, so I'm removing one. The key piece is going to be on line 15 here, page 18, line 15. If the court finds the tenant is obligated to pay rent and is failing to do so, the court shall order full or partial payment into court of rent as it accrues while the proceeding is pending. This proposal takes away the court's discretion to order partial payment. So the court would only be allowed to order full payment into court under this section if the landlord filed the motion requesting it.
So with this, if the landlord and the tenant come to an agreement, would this prevent that agreement? If the landlord were to say, all right, you owe me $5,000, but I'll pay $3,000 and you move out, would this language prohibit the court from allowing that agreement moving forward?
There was some concern with that, so they did add language on the next page.
Oh.
Yep. So the bill removes that initial discretion of the court to order a partial payment. But then the top of page 19, there is a subsection G that allows the tenant to request by motion that that amount be reduced. At one point that was struck, but ultimately the House Judiciary Committee wanted to keep it to allow the tenant that opportunity. There could be circumstances where full rent may not be appropriate. If, for example, there is some sort of habitability issue with the unit where the court may find that, full rent is not appropriate. And then they added the subsection I, which says the parties may come to an agreement at any time to reduce the amount ordered to be paid. And then ultimately, Mr. Chair, your question, there's nothing that prohibits the parties from coming to a global agreement on the ejectment process if they wanted to. Okay, now to the next section on page 19. This is all the current ejectment process. What do you do with the property of a tenant that remains on the premises after the eviction? So notice termination's been provided, tenant remained, ejectment case is brought, landlord gets the writ of possession from the court, the landlord is entitled to the lawful possession of the property. What happens? The statutory sections that govern say that the writ of possession has to be served by a sheriff on the tenant. And then depending on whether it's an expedited process or not, the sheriff has to wait a certain statutory amount of time, and then they will come back. And if the tenant is still there, they will physically remove the person. The default is 14 days. So the writ of possession is issued to the landlord, sheriff serves 14, not later than 14 days later, the sheriff comes back, removes the person. If it's a rent into court escrow proceeding, and the defendant is not paying rent into court after it's been ordered, and the court issues a writ of possession under that section, it's reduced to 7 days. The writ's issued, sheriff delivers, not later than 7 days, come back, execute, remove the person. If it's an unlawful occupant expedited hearing, it's 5 days. writs issued, sheriff delivers, not later than 5 days, comes back and physically removes the person if they're still there. I bring that up because it impacts this language that you have on page 19. There was some confusion among some members of the committee, even among myself as I was reading this section initially, about what do you do with the person's property after they've been physically removed? How long does the landlord have to maintain that property? The current section is they have to maintain the property 15 days after the writ is served, or upon legally being restored to the property, whichever comes later. So under just the default circumstances, as I mentioned, the writ's issued, the sheriff serves it, not later than 14 days, comes back, removes the person. The next day, the landlord could then dispose of the property. What this change will do is it says that immediately upon the landlord being restored in possession of the property. So under the default circumstances, that would probably be 15 days. Because the sheriff has to wait 14 days to come back to remove the person. So, but it could be as short as 6 days. Because under the expedited hearings, the writ's issued and the sheriff only has to wait 5 days to come back and execute once it's been served. So based on this amendment, the landlord could dispose of the property potentially 6 days after the writ has been served on the defendant. And so that may be something that you want to talk about, whether that's appropriate time frame.
So I think if they are, how would the landlord not be able to immediately dispose of property with the new language? How is it 6 days? I'm missing that.
Yeah, 1 second. Okay, so the default language under the ejectment process is when there's a judgment for the plaintiff. And as you can see here on these last lines, the writ directs the sheriff to serve upon the defendant and not earlier than 14 days after the writ is served, put the plaintiff into possession. So the sheriff serves it, and then they have to wait another 2 weeks before they can come back and actually physically remove the person. Under your current statutory section with what happens with the property, the landlord has to wait 15 days after the service. So in theory, default circumstance, sheriff serves the writ, 14 days later comes back, removes the person. Landlord has to wait 15 days after service. So those things would happen relatively, 1 day apart. But under some of these sections, for example, for the unlawful occupant expedited hearing process, right here, the sheriff serves the writ and not sooner than 5 days after it's served. So it's not 14 days under an unlawful occupant section, it's only 5 days. Similarly, with the payment of rent into court section, if the court orders payment of rent into court, the rent escrow, and the tenant doesn't pay the rent that's ordered due, the landlord can get an expedited writ in that event. And in that section, the sheriff only has to wait 7 days. So the default is the 14, but there are circumstances where it could be less. And so with the change that you have proposed in 772, I just want to make sure you are aware that depending on what section the writ is issued for, it could be less than 14 days where the defendant is made aware that they've ultimately lost the ejectment case. It's served on them, and now they may only have 5 days to be able to remove their belongings from the property before the landlord can then dispose of it. So,
That makes sense. Thank you.
okay. Now, page 20. Now we're getting to what you have here is a new subchapter. So you have the current subchapter that I mentioned that already exists here. This is creating a new subchapter. Before I jump into the language directly, I'll just make a few comments. The new subchapter will only govern an ejectment that's brought due to non-payment of rent or for breach of the terms of the rental agreement. That little cheat sheet that you have, the first three, the A and the B. So this is only for the kind of quote unquote just cause terminations or just cause evictions. Anything else would have to go under the current subchapter that exists. So that's the first thing to keep in mind for all of this new language. It's just for a subset of determinations. The second thing I'll comment on is, I would say, potentially 90% of the language in this new subchapter mirrors exactly what exists in this subchapter. And I'm bringing that up because I mentioned this to the House General Committee at the time. It may not be worth it for you all to create an entirely new and separate subchapter to accomplish what the bill ultimately accomplishes. You may be able to accomplish this by simply adding a section into the structure that already exists. And I'll get to that in a second with the expedited hearing, but I'm just mentioning it to you. It's a policy decision for you all about what makes the most sense. But just understand that everything that we're going to walk through with this new subchapter, nearly all of the language mirrors what's already in the current statutory language. So diving in, page 20, section 4861. Key things to focus on, lines 15, that this is only for termination of the lease under 9 BSA 4467A and B. And that's what I mentioned, the non-payment of rent or breach of the rental terms. Everything else in that section, current language that's in subchapter 3. Next section, 4862, mode and service of process. This is that the process issues as a summons requiring the defendant to appear and answer to the complaint of the plaintiff, which states that the defendant is in possession of the lands or tenements in question with a description thereof, requires that a copy of the rental agreement be provided, requires that the notice to terminate be provided as part of the complaint. Key language on lines 4 and 5, including the affidavit required by 9 BSA 4467B2B. That's a new subdivision that's being added. If the landlord is terminating the agreement under B for some sort of breach of the rental terms, the statutory section is being amended to require that the landlord provide the tenant an affidavit with the termination notice that outlines the specific facts, these particular facts in sufficient detail to inform the tenant what the justification is for the termination of the agreement. So that's new, requiring that affidavit be provided. This section is saying that affidavit needs to be provided in the complaint if the case is being brought under this subchapter. And the complaint has to include a copy of the rent ledger if it's available. Next section, answer and commitment. So answer has to be, accompanied by an affidavit. Standard language here of what already exists. Upon receipt of this, the sub B on lines 13. This is one of the key differences between the current statutory section and what exists here. Upon receipt of an answer to a complaint based on a termination under 9 BSA A or B, the court shall set a final hearing date not later than 90 days after the filing of the complaint, absent good cause. That time frame does not exist in the current subchapter for ejectments. The only time frames that are built in the current subchapter for ejectment are related to the rent escrow and the unlawful occupant. So under current law, there really is no timeline in statute that the court has to set hearings for an ejectment action. I believe they testified that their goal is to resolve the ejectments within, I think it was 180 days. Shorter than that, defer to Judge Zoning, but there's no statutory requirement. So what you're doing in this section is you're saying that for an ejectment brought into this new subchapter, the court has to have a final hearing within 90 days after the complaint has been filed. That timeline, the sub B2 here, timeline doesn't apply if the plaintiff is already in possession of the land or tenements or has received a writ of possession for the land or tenements. It could be that the landlord is bringing the ejectment action because the individual still owes back rent or owes damages, and that's what the landlord is seeking under the case. But the tenant has already vacated the property. And so the landlord already has the physical possession, but they're still moving forward to ensure that they receive the ejectment writ of possession or because they're seeking some sort of damages from the tenant. And so in that case where the landlord already has possession of the property, the 90 days wouldn't apply. Next section, bottom of 21 and 22 is just default. I would argue this probably isn't legally necessary, but it states that the defendant can file. If the defendant doesn't file an answer as required, then the plaintiff can file a motion for a default judgment. This is authorized by the rules of civil procedure.
And the rules, I guess the sub rules regarding setting aside a default judgment, those are in Rule 55.
I believe so. Rule 55 covers default. So
Yeah.
Okay. Here is the other than the 90 days that I mentioned, that's different than what currently exists in statute. This next section is really where I would hone in on for what are we doing that's different than what currently exists. 4865 is expedited hearing process for threatening behavior. All of the, I would say 90% of the language that's in this new section is based off of language that currently exists for the unlawful occupant expedited hearing. So that's where I'm just mentioning that none of this is new. What is new is the timeline that's being put on it here. So a few things I'm going to hone in on. First, in the sub A1, the case has been filed. The plaintiff may file a motion starting on line 5. The plaintiff may file a motion for a judgment that the plaintiff is entitled to immediate possession on the grounds that the defendant's continued occupation of the land or tenements is threatening the health or safety of other residents, the landlord's agents, or neighbors. And what I'm going to do, if you hold that page 22, I'm going to ask that you go all the way back to page 8. Because this is the termination notice section, B2. Look at lines 16 through 19. When termination is based on what it will be if it moves forward as it's written, when termination is based on acts of violence, damage to the dwelling unit, or other activity, any of which threatens the health or safety of other residents, the landlord may terminate the tenancy by providing notice, and it's being reduced to 5 days. That could be one instance. There's no requirement in that language that the activity be ongoing. So there could be one event that the tenant does something that threatens the health and safety of other people, and the landlord is choosing to move forward to terminate the rental agreement. But when you move forward to this new section for the expedited hearing, it says on lines 6, 7, and 8, the grounds that the defendant's continued occupation is threatening the health or safety of other residents.
So can you remind me the definition of immediate possession, does that mean that the sheriff is serving the writ of possession and then if they're waiting that additional time, or if they're serving that writ of possession and then they're
Immediate,
physically out?
immediate possession isn't defined. It's just it's the language that's used in the chapter about ejectment. It's the landlord is arguing to the court that I have legally terminated this rental agreement in compliance with the statutory section, so I'm entitled to possession because the individual has remained after the termination date that I provided them lawfully. So I'm asking the court to give me immediate possession of the property. And what I made that, I brought you back to page 8, and I'm making this distinction because this was discussed in House Judiciary and the language difference is intentional. The committee discussed that it may be the case that you, as a policy decision, want to allow a landlord to terminate a rental agreement because of one instance of something occurring that's threatening other people. Policy decision, yes or no? The next policy question is, do you want to authorize an expedited hearing for an ejectment case based on one instance that occurred? Or do you want there to be something more to justify a significantly reduced ejectment case? And so what that committee landed on was that you can file the motion to ask for the expedited process in court, but you need to demonstrate that there is ongoing element of a threat to the health and safety of other people by the tenant remaining in the property. So if that threat no longer exists, then you can still bring the ejectment. You're just not going to get the expedited hearing. The next piece here, most of the language in this section is just, the motion is filed, can be served with the complaint or separate from the complaint. It allows the defendant under subsection C, defendant can oppose the motion by filing an affidavit, written statement, memorandum in opposition. And then you get on the next page, if the defendant fails to appear or to provide, information or response, then the plaintiff is entitled to judgment by default. All of this language, on page 23, most of the language on page 22 is exactly how the current unlawful occupant section is written. So it mirrors what currently exists. The key things I wanted to focus on are the first piece I mentioned about the continued occupation, but then next look at lines 14, 15, and 16. It says that the hearing on the motion shall be held promptly anytime after 10 days notice to the parties, but not later than 21 days after the motion is filed, absent good cause. And this was another piece that I wanted to highlight for you all. You could run into situations where the hearing could be held prior to the defendant even filing an answer to the complaint. Because the language says that not later than 21 days after the motion is filed. And if you look at the top on the sub 2, A2, lines 10, the motion can be filed with the complaint. So the landlord can come in and file the complaint and file the motion for the expedited hearing at the same time. The complaint has to be served on the defendant, and then the defendant has 21 days to file an answer. So conceivably, you could have a situation where you're telling the court that they need to have the hearing on this motion before the answer's even been filed. Now, the language here allows the answer to be filed after the hearing. And it also says that the hearing has to be not later than 21 days absent good cause. So the court could say, you're filing the motion when you file the complaint. The defendant has 21 days to answer the complaint. I'm not going to have the hearing until after the initial complaint has been filed, and I have good cause to do that. So I'm not going to hold this hearing within 21 days. You've built in those flexibilities I'm just highlighting for you all, it may be a question you want to ask the court about. It seems like, you're kind of running up against the answer date and this hearing date around the same time. And maybe something you want to extend that out for.
Yeah, I was gonna ask, I know we're not in markup, but for line 14, if we were to take the 10 days and just make it 21 days, would that address the issue that you raised?
I don't think so, because the B there, the 10 days, that exists in, the unlawful occupant, and I think there's similar language in the rent escrow. That's just telling you how much notice you have to give to the parties. You have to give the parties 10 days notice before the hearing, but it doesn't tell you when the hearing actually has to be. I could set the hearing 30 days out and give you 30 days notice. It's just saying that before you set the hearing, you got to give the parties 10 days notice before that hearing occurs.
We can revisit it.
Yep.
Thanks.
Okay. So again, in this section, the two things I wanted to mention are about the fact that there needs to be a continued occupation of the defendant is what is threatening the health and safety of others. And then I wanted to mention the 21 days, which somewhat mirrors some of the current process, but I think it potentially could be problematic and something you may want to examine. When we get down to the bottom of page 23, next section, cost judgment.
Before you keep going.
Yes, sir.
Looking at default judgment, do we need to cross-reference Rule 55 for that, or is it applied? Because I know we cross-referenced in the other section.
Right. I would pose that question to the judge, because it's mirrored on what currently exists, which does not reference to it. And so, that issue was not raised in House Judiciary. I don't think that you need to, but the judge may do it.
Thank you. Senator Moss.
Yeah, I got one question on page 22, where plaintiff may file an order for judgment. Plaintiff gets it immediately in possession. What does that look like exactly? Is that someone going down with a writ executing it, and if the individuals aren't there, it still goes into immediate possession? They come back, find their doors are locked, and
No, this is just the motion into the court, asking the court for an expedited hearing on the claim. And again, the immediate possession, entitled to immediate possession as it's used here is just, you're asking the court to say, I'm entitled to possession of the property. And I'm asking you, court, to give me that writ determining that. So even under this expedited hearing, as you can see under subsection E, under page 23, if the court issues the judgment in favor of the plaintiff, then it issues the writ of possession. The sheriff has to then go serve it on the defendant. And then lines 17 and 18, similar to the unlawful occupant, not sooner than 5 days after the writ is served, come back, remove the tenant at that point in time. And then keep in mind that factors into the change from earlier about when the landlord can dispose of somebody's property based on the amendments to immediately after being legally restored to possession. The landlord can dispose of the property at that point. So under this section, it could be 6 days later after the writ is issued that the landlord could then dispose of that property.
so when they mention the 5 days, do they take holidays and weekends into consideration for that, or that included in 5 days?
That would be my understanding of this, is that the day is a day. So it's the 5 days, it's 5 calendar days, and it would not, whether the sheriff is, let's say the sheriff is never not working, right? But whether a sheriff is going to go on a holiday, I would say it's up to that office. It says not earlier than 5 days, not sooner than 5 days. So it could be 6 days, could be 7 days, could be 8 days. It's just saying you can't do it before the 5 days. So, and then, and just so you're aware, in some instances, the court may mandate a different time period. The court could mandate that it be 10 days, or that it be 14 days, or that it be 30 days. There's nothing, my understanding is that the court can extend those timeframes. But okay, the next section, as I mentioned, it mirrors what is currently there under the current process. If the court finds the plaintiff is entitled to possession, the plaintiff gets the judgment for possession and rents due if applicable, including damages, costs, and when the rental agreement so provides, reasonable attorney's fees. That mirrors what currently exists. The writ of possession issues on the date of the judgment, directs the sheriff to serve the writ on the defendant, and then here's the similar default provision of not earlier than 14 days. A new section being added here about property of the tenant remaining. It mirrors the current section that exists in the current subchapter that we looked at, and so it uses the language immediately upon being legally restored. And then the last piece is here, and we're coming to a conclusion. We're going to talk about trespass. This section says after being legally restored to possession of the dwelling unit or leased premises, the plaintiff may issue the defendant an order against trespass for the entire premises subject to the ejectment action in accordance with 13 VSA 3705. And there's an amendment to 3705 here in the next two sections. Section 4 states that the purpose of Section 5 is to overrule the Vermont Supreme Court's decision in State v. Dixon and allow the landlord of the dwelling unit to obtain a no trespass order prohibiting the tenant's invitees or licensees from entering the dwelling unit's common areas if the invitee or licensee subject to the order has violated the terms of the lease agreement. And then I'm going to mention Section 5, the language, and then I'll pull back a little bit and just talk briefly about State v. Dixon. In Title 13, Section 3705, about unlawful trespass, this would be adding in a new subsection that states that nothing in subsection A or any provision of law to the contrary, the landlord of a dwelling unit may cause to be served an order against trespass that prohibits a tenant's invitees or licensees from trespassing in the dwelling unit or any of the dwelling unit's common areas if the tenant consents to it, the invitee or licensee subject to the order has violated the terms of the dwelling unit's lease agreement, or the invitee or licensee has violated a state or federal law while on the premises of the dwelling unit. And in the top of page 26 simply references the definitions of dwelling unit and tenant as they exist in the residential rental agreement chapter. So what is State v. Dixon, and what is this?
Before you go to State v. Dixon,
Yes, sir.
I'm assuming you've gotten this question elsewhere, but lines 16 to 17, can you explain how the guests, how they can be held to the terms of the lease agreement? And if somebody's visiting, can a landlord say you're not paying rent, which violates the lease agreement that you're not a party to, therefore getting that order?
I don't know that you would ever be able to make that argument because the individual hasn't, agreed or isn't a party to that contract. There is a section in the residential rental agreement chapter that requires that a tenant ensure that the guests of the individual are, essentially complying with the tenant's obligations of the chapter. And so I do think that there is kind of a statutorily implied requirement that a guest has to comply with the terms of the lease agreement. So I think there is a statutory section that you can point to that would require that. So State versus Dixon, a case 1999 where an individual who had been issued a no trespass order against the property was on the property because the individual had been invited there by a separate tenant, and criminal trespass case was brought against the individual, and the Supreme Court ultimately reversed on that, citing common law rules that the landlord can't prohibit an individual from being in the common areas if that individual has been invited or is a guest of an individual tenant who has lawful possession of that unit. So this language is intended, as it's mentioned in the purpose section, to kind of overrule portions of that case and authorize a landlord to issue that no trespass order and to exclude those individuals if one of those three conditions is met. First, if the tenant consents to it. At that point, the individual doesn't have, they haven't been invited, you would argue at that point. So I think the real questions that you'll get, from some of the advocates are, what about the other two? Are you, allowing a landlord to potentially restrict an individual's right to have their own guests onto their property? And I would say the section is intended to allow a landlord to do that when that guest is violating the terms of the lease agreement or violating state or federal law on the property. And this section would allow that. And, the State v. Dixon case was not based on any constitutional right that a tenant has to invite and have whatever guests they want on the property. It was based on reading the statutory language about who has lawful possession of the given area, and then looking at common law rules to help supplement the current statutory section. And the court said that the landlord could not lawfully exclude someone from the common areas of the property if that individual had been invited onto the property from a lawful tenant.
Quick question, I haven't looked at this rule for a long time, but the quiet enjoyment of the property. Can you refresh my memory on what that implies?
I'll pull up the statutory section, and I haven't reviewed cases there in a while, but this kind of feeds into the question that was being asked a second ago. This is the current statutory section, and it talks about, the tenant shall not create or contribute to the non-compliance of the dwelling unit. The tenant shall conduct himself or herself and require other persons on the premises to conduct themselves in a manner that will not disturb other tenants' peaceful enjoyment. Tenant shall not deliberately or negligently destroy, deface, or damage any of the unit, etc.
So is that the quiet enjoyment of the property?
Yes. Okay. Yes, I would say, there the B, right? The tenant has to conduct himself and require other persons to conduct themselves in a manner that does not disturb other tenants' peaceful enjoyment of the premises.
Thank you. Senator Host.
I have a question that goes way back, because I noticed that as you were reading that, the tenant is also required to supply actual notice if they're terminating the lease agreement. By the change with this being able to tack it to the door, does that mean the tenant could tack that notice to the door of their apartment and leave?
Do you mean if the tenant is wanting to terminate the agreement with the landlord?
Yes.
Okay, so not a sublease situation.
Right.
Okay.
Because if to me, it looks like we're changing the definition of actual notice, so it would mean that would be actual notice to the landlord from the tenant.
Right. So the tenants, this question came up in Senate Economic Development recently, and they asked, does the same notice requirements apply to a tenant? And my understanding is they don't. Like a tenant is not equally obligated under the statutory section to provide a notice to the landlord before the end of the rental agreement that the tenant is not going to extend the agreement. Now, I know you read that in a lot of leasing, lease agreements and lease terms. I've had in the lease agreement before. I think one could potentially argue that creates a contract. Or do you have some sort of, contractual obligation by having a review it in writing? Separate argument. The statute, I don't think contemplates or requires that a tenant provide any notice to a landlord.
Well, the statute you just had up had said that the tenant may terminate the lease providing actual notice.
Right, and so the question there is, I agree, there's a question about if the tenant is going to abandon the property and provide notice, what happens if they abandon, et cetera. So that section, yes. They would have to comply with the definition of actual notice. They could add it to the door if the address of the landlord is unknown. So keep in mind, that's the condition on the actual notice. So you would still have to give it to the landlord unless you do not know the address of the landlord, in which case, yes, ma'am, I agree, you can probably just tag it to the door. Yes.
So, I do want to switch gears here, because we have Hillary for
Yes.
11:30. I want to just respect everybody's time here. So there were just two other small sections that I think we'll have to revisit. Did just want to get some more information on the affirmative defense, which is on page
Okay.
14. And
Yes,
then
sir.
just also the bifurcation, the rental agreement on page 16.
Yes, sir.
But I assume that won't take too long at another date, so we can get to that when we get there.
And if you have any questions, I pulled together a few summaries for Senate Economic Development Committee. I'd be happy to share those with you all if you all find that helpful. I'm gonna make sure you've got the correct version of that. So I'll send that back around to you also, you have it. And happy to come back and answer any questions.
Fantastic, thank you. You can stay on live, but I'm gonna go find Sarah to do 2:49. I'll be back. weeks ago off. Okay, we are back to Senate Judiciary on April 8th. We're switching gears to page 849. And briefly, can you just remind the committee what the bill does, just the 10,000 foot view and floor space? Sure.
For the record, Hillary Cheddar aims for the Office of Legislative Counsel. In the 10,000 foot view, this bill proposes to create a cause of action against any government officials, state, local, or federal, who violate Vermonters' constitutional rights. There is some language that gives guidance to courts about what that cause of action would involve. These are subsection C and D. That any defense available to defendants under the federal and the parallel cause of action, 42 USC 1983, would also be available to defendants in this cause of action, and that it is the legislature's intent that this section be construed consistent with how courts have construed that federal section 1983. The 10,000 foot ends there, but happy to answer any questions.
So just to clarify this, really, so in terms of state, local officers or agents in government, under current law, they can already be hailed into state court. And this is changing it to add to that list to allow federal agents or officers also to be hailed into state court. Is that right?
I think almost I misheard. But yes, under current law, under the federal section 1983 statute, suits against state and local officials for constitutional violations can be brought generally in district court, but you do see some state court decisions on section 1983. But section 1983 does not apply to federal officials who violate the Constitution. In a very, very narrow set of factual circumstances, there is a judge making a cause of action. Have you heard about Bivens action? That can be brought against federal officials for constitutional violations, but that's in very specific factual scenarios, so not all constitutional violations. So that help clarify.
Yes. Senator.
I'm just wondering, so in the pursuit of our duties in the legislature, I was under the impression that we had certain immunity, qualified maybe.
You have absolute for duties undertaken on the floor and pursuant to your office.
So, and I'm looking at page 2, lines 3 through 5. So it doesn't, this subsection doesn't alter, then create or support an absolute immunity defense. So I'm wondering, federal agents have qualified immunity.
Generally, yeah.
So how does this allow, I'm thinking of South Burlington, where we had ICE officers and the Vermont State Police and other law enforcement agencies all at this one incident, and there were accusations that people had them thrown to the ground or other things. Am I right that they can't be sued currently? And then I'm wondering how this would make it that it could be sued if it doesn't affect qualified or absolute immunity.
It's a great question. So I will take it out of the specific incident, just so I'm not opining on a specific incident, but the kinds of facts you described could potentially give rise to an excessive force claim. Not saying that that claim would prevail, but that kind of factual scenario could support at least that kind of allegation. And under current law, an individual could bring that suit against state or local officials under section 1983. But there would not be an available cause of action to bring suit for immunity damages against any federal agents. The Bivens action does not apply to those excessive force.
But I guess what I'm not understanding.
Oh, sorry.
Yeah.
The second part.
Yeah.
The immunity part. So the way this would work and what this language means is that those defenses are still available. It's not a resolution of those defenses. So if you brought a cause of action for excessive force against a law enforcement officer, you would describe your allegations in your complaint, and the officer in their motion to dismiss or their answer, their response, they would say, I'm entitled to qualified immunity, and the court would resolve the qualified immunity arguments. They would look to whether there's a clearly established law making that a clear constitutional violation, and whether the officer would have reasonably understood that at the time. Qualified immunity gets resolved early, and it can also be appealed. The denial of qualified immunity may be appealed. So that would all get resolved. The fact that qualified immunity is available doesn't mean that, or the fact that it's available means the defendant can raise it, not that it will automatically apply or automatically result in the dismissal of a suit.
So let me restate it and you tell me if I'm right. So in other words, this allows for suits to go forward. It doesn't affect the affirmative defenses that the potential defendants of those suits might face.
Correct.
Okay.
Suits can be filed, and then the defendants can raise the affirmative defenses that they would have available to them otherwise. This second line is intended to kind of limit this affirmation of qualified immunity to this provision. Vermont law elsewhere doesn't explicitly codify qualified immunity, although courts have found it applied and be available in other contexts. So this is a way that language limits this recognition of qualified immunity to this section, and would the intent of that language would be to prevent a court from saying, look, the legislature thinks qualified immunity should be generally available. That language would indicate that that's not the legislature.
Thanks.
Senator Rose, answer next.
So under, you said it was Bivens.
Yes.
And so in the instance that Senator Bruin pointed to, a judge has now said that the Fourth Amendment rights of the people detained were violated. Would that be a space where Bivens would apply and the federal agents involved could be sued?
Currently, no, not under a Bivens action. I'm looking back at my notes for the Bivens claims. So Bivens is only available in a few factual scenarios. The original Bivens case did involve some excessive force claims, but in a very limited context. So if the committee is interested in exactly how a Bivens claim could play out in a factual scenario about a protest in excessive force, I'm happy to do a little further case law research. My understanding of the way courts deal with Bivens actions is that unless it's just like the factual scenario that they've already recognized, they wouldn't recognize an extension. So the factual scenario where they originally recognized it is federal narcotics agents raiding a home and throwing someone to the ground during an improperly executed warrant. Excessive force occurring in another context, so by law enforcement officers on the street at a protest, would likely be something that a court would not recognize as available under this.
So this is not about on the street at the protest. This is about the people who were in the home and were illegally detained. A judge in releasing them said, yes, their Fourth Amendment rights were violated.
Thank you for the clarifications.
Yes.
So your question is,
Would we need this in order for the agents that made those arrests to be held accountable for violating those people's constitutional rights?
interesting, and that would be Fourth Amendment search and seizure rights. There's some factual overlap with the original Bivens claim. I think some Bivens cases have looked to which federal officers committed the action and found that if different officers did the same thing, it takes it outside of available Bivens actions. And there are several cases where federal courts have explicitly said, like, immigration is a different context than what we've looked at. Immigration officers doing things is different from the previous Bivens scenarios we've recognized. So without offering any legal advice or opining on particular scenarios, I think that Bivens cases that we've seen would consider immigration officers committing Fourth Amendment violations as distinct from the kinds of cases where they recognize that this is available.
And then what about an instance where state or local officials aided those federal officers in violating? They didn't do it themselves, but they helped make that available. Would they be able to be held accountable?
So under existing section 1983 federal case law, there is, I believe, recognition of claims for conspiring to violate federal rights. So that would be the kind of thing that could be available. I think there's also under section 1983, if federal officers conspire with state or local officials to commit federal violations, some cases have recognized that those things come before it under 1983.
So just to clarify though, currently, if a state or local officer or agent violates somebody's rights, they can still be sued in federal court for violating. So
Correct, under section 1983. Yes. The main distinction of the bill is also making that state cause of action available against federal officers or officials. Those
detailed
cases would
into
still
state court.
into state court. It's still highly likely that those cases would end up in federal court because we heard from testimony from some other witnesses, but there are several statutes about federal court jurisdiction and when you can remove a case from state court to federal court. And there are two instances that could be relevant here. One is if you bring a case against a federal official acting in their duties, they can remove that to federal court. And if there is a federal question on the face of your complaint, so if you are bringing suit under a federal statute, or if your state law claim implicates a federal constitutional question, which I think this one would, that would be another basis to remove a case from state court to federal court.
And for that type of removal, does it require the consent of both parties?
Yeah.
Okay.
So removing a case from state court to federal court, you file papers with both the state court and the federal court. The federal court will generally then give the other party, the plaintiff, a chance to respond, and then the federal court rules on whether removal is proper or not. They either keep the case and say, yes, you properly removed, it's in federal court, or they'll say, nope, we don't have jurisdiction, go back to state court. So there is a chance to respond, but it is ultimately removal as a prerogative of the defendant to at least initiate, and then the federal court resolves whether it has jurisdiction or removal is appropriate.
Makes more sense. It really doesn't. At least to me, it seems pretty, like a pretty small change. Any other questions for Ledge Council? Oh, sorry, you had a question, right?
I had one,
Sorry,
but over
sorry.
the course of Senator Bihowski's question,
My-
your follow-up, it actually answered my question. I was just thinking about how this pertains to state and local law enforcement versus federal, and it doesn't change anything state and locally, but it is just wrapping in that middle part. So clarification between those two questions was great. So I'm all set.
Thank you. Any other questions from anybody else? Does anybody, do we want to wait a little bit and think on this a bit more? Because it seems like people had thoughts and questions. You want to vote tomorrow, or are folks ready to vote today? Any other witnesses that we want to hear from? Anything else from like this?
Nothing else?
Okay. So,
I guess not. I'd make a motion that we vote it out favorably.
is there a second? Senator Matos, do you want to? Any further discussion?
Senator Norris,
No.
Senator Baruch,
Yes.
Senator Matos, yes. Senator Bihowski,
Yes.
Senator Fashin,
Yes.
4-1.
Does anybody have a desire to report this on the board?
I have a picture, but I don't need to.
Guess that fits me out.
Yeah, I don't mind, I don't know, I'd be happy. Yeah, I'll report that. Thank you.
It is.